Right, good afternoon, everyone. Can everybody hear me? Brilliant, great stuff. Thanks for giving up your time in the lunchtime slot. I'm Jason Chapman. You can't hear? Yes, I can hear. Sorry. You've got music? Oh, okay. Right, is that better? Brilliant. Is anybody else hearing music? No, great stuff. All right, good afternoon, everyone. Like I say, I'm Jason Chapman. I'm an ombudsman at the Legal Ombudsman. Firstly, thank you ever so much to the Solicitors Regulation Authority for allowing me to come and speak to you today, and thank you all for giving up your time to listen to what I have to say. I'm going to be covering a couple of things today. Just a quick whistle-stop tour of who we are, what we do, and some of our statistical information, what we've been doing in the last 12 months. And then what I want to share with you is we've commissioned some research, because what we're finding is there's a large number of complainants who are coming directly to us without firstly approaching their firm. So we've done a bit of research as to find out why that is. Before I start, like I say, I would reassure anybody at a firm, we don't look at complaints where the complainant comes directly to us unless they've complained to their firm first. There's only very specific circumstances where we would do that. For example, if the firm was closed or had been intervened into, or if the relationship between the solicitor and the client was so bad that it makes more sense for us to approach the firm and deal with the complaint that way. But even in those circumstances, we would treat it as a first-tier complaint. So as I say, I'm going to share the latest data with you first. Obviously, we're sitting in the Legal Ombudsman. We think everybody knows exactly who we are and what we do, but I come to events like this, and the knowledge it isn't always consistent. So just to be clear, what we do is we look at complaints from people who've received a legal service about their legal service providers. And we're an independent body. We're not a consumer organisation. We undertake an independent investigation into the level of service provided, and then produce a decision from the Ombudsman, like myself, which is binding on the parties. So, in 2021, which is the year of the pandemic, we found that we received almost 6,500 contacts from customers wanting to complain about their lawyer who'd not raised a formal complaint with the service provider first. We would always sign and post them in the first instance back to their solicitors or barristers, but what we wanted to do in the research that we've commissioned is understand why people are coming to us directly. So we want to share that with the profession. We want to let you know why customers are not raising complaints with them firstly, and tell them from the findings we've made what they can do to make it easier for the customers to raise issues to them so they can deal with them. So, as I say, in the pandemic year, we have been still quite busy. We've been working remotely as an organisation. Our office has been now just only reopening after 18 months. But what we're finding is it's been pretty much business as usual. The most prevalent form of area of law that attracting the most complaints is residential conveyancing still, even though there's not been many house sales during the pandemic, followed by fairly consistent personal injury, wills and probate, family law, and then litigation. And then we get all the other areas of law as well: criminal law, mental health, landlord-tenant, land law, and so on and so forth, forming a much lower proportion of our overall complaints. In terms of what they're complaining about, again, this has been fairly consistent over a number of years, but the most consistent and most common forms of complaint are delays and failure to progress a matter during the solicitor acting for the client, failure to advise them, poor communication, costs, and by that we mean costs information and the costs themselves, and a failure to follow instructions. With the first few, what we see as being inherently preventable. Certainly delays, matters should be progressing reasonably. Poor communication is something that the solicitors and barristers can always address, and a failure to advise is just part of a reasonable service. So we see that as something that should be happening. So, in terms of what the commission that we researched for the people who are coming directly to us, who haven't come to their legal service provider first, we found there was there was 5 main reasons that they quoted for coming directly to us rather than initially to their solicitors. The first one, it's a lack of confidence that the solicitor, service provider, would deal with the complaint fairly, or they were worried they'd withdraw. The other thing is that people are a bit intimidated about complaining directly to their lawyers on occasions. They think that, you know, somebody who's paid to argue for a living is going to be able to out-argue them. They see themselves as being the professional, being the lay person, that coming up against a professional, and they find it difficult to do that, to complain. The other thing that we found out coming through the research, which was more concerning to us, is a lack of awareness of the service complaints procedure, and that the customer could even make a complaint to the firm or to their complaints handling partner. We found this was a result of poor signposting, a lack of information, and I'll talk a bit about these in more detail in a minute, but these are the sort of the headline issues. The third one was a lack of understanding where we fit into the process. People think they can come directly to us, which isn't the case. But equally, we found it through our research, from the evidence and the data we're collecting, is more than half of the people who came to us directly weren't told about the existence of the Legal Ombudsman at any point. They just sort of found it themselves, and because they'd found it themselves, they weren't aware of the process, and so they decided to come directly to us. The last two, the last one I've dealt with already. Complaining is unpleasant, especially in this sphere. Customers do feel intimidated, and it's time consuming. People might think, oh, I can't be bothered with it, and so they don't bother. The other thing we do get quite a lot of is in staged complaints handling procedures that we see is people sort of give up after the first stage. They might sort of raise a concern or an email with the fee earner who's dealing with the matter, but then they sort of think, well, I can't be bothered to take it any further. They're given the complaints handling process, which says that then they have to complain to the head of practice, and then they have a meeting, and then we see various different procedures on a day-to-day basis. But people feel if there's more than one stage, they just get fed up and think, oh, right, I've had enough of this now. I'm going to the Ombudsman and seeing if he can sort it out. Like I say, when that happens, we would ordinarily signpost the complainant back to the firm and ask them to complain there. It's fairly obviously, we want the firms to have the opportunity to sort the matter out themselves before it comes to us, because it might well resolve. We're seeing a lot of commercial offers being made at first tier now that we find to be sort of reasonable in all the circumstances. Unfortunately, not all of our clients are reasonable, so they can then come to us. But we wouldn't ever preclude or prevent the service provider from having the opportunity to deal with the complaint before we looked at it. Like I said, the only times we would ever do that is if the firm had closed or been intervened. But even then, we make efforts to contact the former partners to find out if they've got any knowledge or anything, or any comments or any evidence to provide in relation to the complaints that have been brought. In terms of the lack of confidence issue, we say what we say is just encourage feedback from your customer and make it clear what they need to do if they want to make a complaint. And the second thing, which isn't always, it's easy for us to say but less easy to do, which is learn to spot potential issues and complaints so you can deal with them. So a lot of the complaints that we see are sort of a result of a final bill. People don't get the outcome that they want, and you know, quite often there's been no poor service that we can see, that we can determine, but people get upset because they get a final bill which is more than they're expecting, or they've been involved in a litigation matter which hasn't gone their way in court, or they're involved in a criminal matter and they end up getting convicted and sentenced. And a lot of the time these sorts of events generate complaints. But we also equally, we get issues like probate matters where firms are dealing with wills and they just delay and clients are raising issues, concerns about the delay, and they're not being treated as a complaint and they're not being dealt with, and then then sometimes they come to us directly as a result of that. It's a bit corny. I do a 4-hour more detailed course of this, and we go into the whole treat a complaint as a gift thing. It's a bit sort of 90s America, but it is, we see it as being true. You can use a complaint as a feedback mechanism, an opportunity for learning and an opportunity for improvement in terms of your own systems and processes and the way you handle with matters. The Customer Service Institute of Customer Services research in 2013 found that dissatisfied customers tell 15 other people, and 70% of people who had a bad experience will warn others not to use the same organisation again. Another interesting point in that research was that if you complain and the complaint is resolved, quite often you end up more satisfied at the end of the matter than you would have been if you hadn't complained, because they've taken steps to put it right. So the second thing is a lack of awareness and understanding by the complainants about the process. Now this for us is something that shouldn't happen, but we find that it does. Of the 5 service providers who had the most premature complaints in 2021, we found that only 1 published its complaints procedure online, 2 asked customers to contact and they've had a complaint for a callback, and 2 had no information online regarding how to complain at all. Now I would say in terms of the firms that have the most premature complaints, they're not bad firms, they're good firms generally. They do a lot of business, so they get a lot of complaints as a reflection of the fact that they have so many customers. But when we found it through our research that 47% of premature complainants who contacted us didn't know how to complain to their service provider. That information wasn't provided up front in a client care letter or sort of terms of business. And equally, in terms of the website, the SRA's 2018 transparency rules require service providers to publish complaints procedures on their website, and we're finding that not many have done that. So there's a gap there. So if somebody doesn't want to raise an issue with their fee earner because they think that the fee earner will drop them or they won't do as good a job, they're not having recourse to the website to be able to go and check what the complaints procedure is, so they can take it further themselves. So what we would ask firms to do is to make it clear how a customer can raise a complaint if they have cause to do so. Have a complaints handling procedure in place. I'm sure you have, but we see firms that haven't even thought about it. A lot of the time they're smaller firms who don't generally tend to get complaints, and then they get a complaint and it's a big surprise to them. But we would always say have a complaints procedure in place so it's clear how your clients can complain. Include information in the client care letter. I mean, obviously you will send client care letters, you tell people what they're being charged and how they're going to be billed and who's going to be dealing with their matter. Tell them about the complaints procedure at the same time, or cross-reference them to a separate document if you don't want to put it in the client care letter itself, which you then include. It's entirely up to you, but just provide the information up front. And obviously have the complaints procedure on the website, if you have a website, telling the complainant what they have to do and who they have to contact. And like I said, the real trick to this, and I know it's not easy to do on a day-to-day basis, is try and recognise complaints and potential complaints and address them before they go further. And like I say, just to reiterate, because it is an important point, we won't accept complaints for investigation unless the service provider's been given the opportunity to resolve the complaint first. What we want the firms to do is to be able to address the matter so they don't come to us. The next bit is how to recognise a complaint, because we realise that not every complaint comes in on a letter with a big sort of bold formal complaint in red at the top of it, so you can easily see it. There's what we call the expression of dissatisfaction in our scheme rule, which is what we can determine to be a complaint. But there's a range of queries that you might get as a firm from your clients. From raising queries to the formal complaint. Now at this end, the formal complaint, that's easy because you know you've got a complaint. At this end it becomes more difficult because it's really then it's determining, has that person made a complaint, or have they just made a comment, or just raised an issue of concern. Somebody might phone up and say, you sent me a bill today, it's for £4,500, is that right? Now we wouldn't say that was a complaint. It might lead to a complaint, but in itself it's just a query. If you were saying, I've had a bill for £4,000, I'm really not happy about it, I wasn't expecting it, you didn't tell me, then they're raising a concern. Now, is it a complaint? This is the question. What we would say, our best guidance is, if you're not sure, treat it as a complaint, or ask your client, are you looking to raise a complaint? Just so it's clear, because what we get a lot of the time is we get complainants coming through to us who think they've made a complaint, or in their minds they've made a complaint to their fee earner or whoever it is, and the firms know nothing about it because they haven't perceived what the client told them as being a complaint, so they haven't dealt with it in that way. So if it's unclear, we would always say treat it as a service complaint, and or at least ask the client if they want it to be dealt with as a service complaint. Some of them might say no, so you can move on, but equally some of them might say yes. In terms of our organisation, it's important and it's a regulatory requirement that you provide details of our existence to clients. We would say we need to be included in the client care letter if you're putting the complaints information in there, and certainly in the complaints process. And at the end of your complaints procedure, you need to make sure that our contact details and timescales are in your final response letter. The final response letter is very important because of our time limits. We can accept complaints about problems that have arisen in the last 6 years, or if it's further back than that, they have to become aware of it in the last 3 years, and that's for like your typical house sale that happened 20 years ago when somebody's bought something, property, and then they're coming to sell it, and then they find out there was an issue at the time of purchase. Their date of awareness would be in the last 3 years, but the matter wouldn't be. But we can still look at that because of the date of awareness. But there's also another time limit that the complainant has to bring their complaint to us within 6 months of the final complaint letter being sent to them. Now, what we find is firms respond with a substantive response, but clients being clients, they don't accept it, so they carry on corresponding, and firms keep corresponding back, and there's this to and froing going on for months and months. We would take it, the final response, to be in the letter that says this is the final response, even if there's supplementary correspondence after that. The clock starts ticking when you think you've given your final response, and you say it's the final response, and you give that time posting information. We have to let in a lot of complaints that would be otherwise out of time because the firms haven't taken that step to confirm to their client that it is the last final complaint response, from which point the 6 month time limit clock starts ticking. If the complainant doesn't receive a response, or they don't receive it within 8 weeks, they can bring the complaint to us at that point. And the 6 month letter, the 6 month time scale that they have to bring it to us within 6 months, they have to be told that in the letter as well. You now have 6 months to bring the matter to the Legal Ombudsman. Because some of them sit on their hands for months and months. We have them where they go away, they come back after 2 years, and something's triggered it again, and they come to us. And if that information is in the final response, we will take it in as a complaint. So in terms of the overview of the complaints process, this is what we advise. Listen to your client. Like I say, if you're not sure, treat it as a service complaint. Listen, is a complaint being made, and try and find out the reasons for the complaint. That's not easy either. We get a lot of very confusing complaints coming to us, and we're not quite sure what the scope of the complaint is. So we have to check. If somebody's complaining about something and you're not sure, check what the issues are. We find particularly with prisoner letters, they handwrite them all. They're scrawly handwriting. This can be confusing, but obviously the complainant knows what they're complaining about. But if you're not sure, you need to check, because if you're not sure and you're dealing with the wrong issue, you can respond to what you think is the complaint, might not be what the complainant's complaining about. What you need to do when you receive the complaint, check here's a complaint, acknowledge and explain the process, and reassure the complainant about any worries that they might have. A lot of complainants are very worried, and it comes out in the lack of confidence thing, that as soon as they raise a complaint, if it's mid-retainer, the solicitor will say, "Whoa, enough's enough. If you're complaining, I'm not going to act for you." As you all know, there's only very specific circumstances where you can withdraw when the solicitor-client relationship has broken down. But complainants don't know that. They might be unhappy about the way things are progressing because there's been delays in the winding up of their grandma's estate or whatever, and they want to complain, but they feel that they can't do that. So you need to, if you do get a mid-retainer complaint like that, reassure them about any worries. Obviously, if you do have a concern that the relationship's broken down, it's irretrievable, check with the ethics department, the SRA, or the regulator, and before you end a retainer. But if you're not going to do that, and you are, irrespective of whether you're doing that or not, you do have to investigate and respond to the complaint. We allow 8 weeks. 8 weeks is more important during COVID times because we know that firms have been working remotely, so they might not have access to the files. It's going to take them longer to get. But even in normal times, we appreciate with matters that have gone on for a while, the file might be large and might need some proper investigation. There might be files held off-site in storage facilities. So that 8 weeks is to allow you the opportunity to get the information you need to conduct your own investigation at first tier and respond. What we would expect when you complete that is let the complainant know what you found out. If you found that you've provided a poor service, what you're going to do to put it right. We appreciate that there's issues with apologising, with insurance and so on and so forth. For our scheme rules perspective, the Ombudsman, we do not treat an apology as an admission of liability. But if you've got any concerns, contact your insurer. But what we would say, if you do find poor service when you've had a look at it and you find things that could have gone better, own it, start and concentrate on what you're going to do to put it right. And that will prevent the matter coming to us in a lot of cases. So, like I say, final response, market the final response. If there's something to take away from today, do that, because, like I say, they've got 6 months, and if the information's not there, that 6 months doesn't really ever start ticking until the final correspondence is finished. And signpost to us as well, provide the signposting information. And then from that, like I say, the complaint is a gift. Learn from it if there are opportunities to learn. What could have gone better? Is there any lessons that your staff could learn from this in terms of the way that they've addressed matters? Maybe there isn't. You know, maybe not all complaints are result in a poor service finding. We find about half the complaints that come to us have got poor service and half haven't. So it's roughly about the same. But if you do discover there's any sort of best practice learnings to come out of it, then you know, take those from it. So that's really where I am with it today. If you have any concerns about dealing with complaints yourself and you want a sort of quick response from ourselves, I mean, I'm here to take questions today. But if you think of something later, or you've got an issue that arises, we do have a technical advice line that you can email at technical.advice@legalombudsman.org.uk. If you've still got generic complaints handling questions that you want to sort of ask us about and we can get our guidance and advice on, that's there for that. An ombudsman will respond to you within 5 working days, so you can sort of get the answer to any sort of burning issues you've got. Our website obviously has a lot of information about complaints and what we would expect and complaints handling and there's a lawyer's section on there, so you could have a look at that. We do CPD courses on more detail than I'm able to give you today, which is a half-day course that we run sort of all over the country on an annual basis on complaints handling at first tier. And we produce publications on our website as well, thematic reports, guidance and consultations. You can sign up to get news on our website, and obviously we're on social media as well. So that's me today. Thank you ever so much for your time, and if anybody's got any just questions about anything about the Ombudsman, I'm more than happy to hear. Yes.
Bearing in mind the family court has recently issued a cost order against parents for wasting time, is the Legal Ombudsman going to actually change its view on charging a refundable fee for vexatious complainants?
What we're trying to do is we try to capture vexatious complainants in the and we would look to dismiss those. We don't have any plans to charge complainants. Obviously, we're an ombudsman scheme. I do appreciate that the firms get charged a case fee if there's poor service directed against them. But no, we don't have any plans to make any charges against complainants. But like I say, what we're getting more robust about analysing vexatious complainants and dismissing them at an early stage. We do sort of have a triage process now where we are looking for that and dismissing. But what we find is that, you know, although there's a disparity really between what firms see as being vexatious and what we do. If somebody's made an effort to complain and go through that process, sometimes they are, and we do tend to spot those, but we just think in most cases, if there's a real concern there, we would at least look at it. So, but yeah, we have been dismissing vexatious complaints. I'll give you an example of one that we had. We had a chap who just kept bringing complaints about the same retainer. He raised a complaint that the firm had delayed it and delayed his matter. We dealt with that one. There was no poor service there, so he raised another complaint about the costs. Then he raised a complaint about failure to advise. Then he raised a complaint about failure to instructions. And it was when he made those very quickly, and we sort of picked them up and just dismissed them. So we know because you've had your chance. But we do find vexatious complaints from time to time, but they're not as common as you perhaps think. Generally, we have very difficult complainants, and we know that they're difficult for firms as well. What I would say about those, if you do get a difficult complainant who's very challenging, phoning you up 10 times a day, we have complainants making threats against firms. Just in terms of the complaints handling process, just push them through and let us deal with it. We're very used to dealing with those sorts of people. You might not want the Ombudsman to have anything to do with the complaint, you might want to resolve it, but sometimes it's better to hand it off to us, because like I say, a lot of the time we sort of pick these up. We're looking to change our scheme rules, so if somebody is conducting themselves in a way that is inappropriate during an investigation, we're going to have the right going forward to dismiss those complaints. We do sort of do it at the moment, but we sort of fudge it. But going forward, we're sort of going to be picking up those more and more. But yeah, I mean, hopefully we wouldn't go through an investigation with a vexatious complainant anyway. Is that okay?
Where you're being very supportive and we can approach you, is it possible once we write our practice and procedure policy for complaints or update it, we send it to yourselves?
Yeah, that's great. That's absolutely fine. No problem with that at all. Do it to the if you send it to the technical advice line, we can advise you on that.
Yeah, I've just got a specific question.
Yeah.
My firm had a complaint to Leo, and the client had not made a formal complaint to us first.
Right, okay.
But Leo did accept it. But what is really disturbing is the client fabricated an email saying that they had made a formal complaint. And I know many other complaints processes require the complainant to sign a statement of truth. And had that been the case here, the client would have faced possible criminal sanctions. So I just wondered, well, first of all, if you've got any advice on how to deal with, effectively fraudulent complaints such as that, and whether you have any proposals to, try and deal with such matters.
We get fabricated evidence. We get it from both sides. We get it from firms, unfortunately, and we get it from solicitors as well. It's not common, but we do get it. What made you? What was the nature of the correspondence that made you think it was? Oh, obviously, it's fabricated. There's an email that doesn't exist. What did it look like?
Well, I did a check. The client suggested they'd sent it to my personal email address rather than the firm's, and so Leo said, well, it's a non-issue there, but
yeah.
I did a check and found, that I'd never received that email, and we asked the client to produce, evidence of the authenticity, and they never did so. So I think it's fairly conclusive.
Yeah. I mean, we, as you're probably aware, we don't work on a particularly high test. It's the balance of probabilities is the basis for what's more likely than not. I would always say if that happens, raise it with your investigator when it gets allocated and let them know. The investigators are trained and very good at spotting fraudulent and fabricated evidence or questioning the veracity of stuff that's coming through to us. Because of the fact that we have to be on guard to spot these sorts of issues. If it's a case that there's a complainant is saying that the complaint's been raised and you're saying that you haven't had it and haven't had a chance to deal with it, I would hope we take a view on that and allow you and sort of pause the investigation and allow you to address the complaints that they've raised and treat it as a first tier response as opposed to second tier response. Allow you a chance, because you might find that you've done nothing wrong, so it's back to at that point, at least you've had the opportunity to look at it, and then we take it on. But you should have always have the opportunity to look at the complaint and respond to it before we do. So, I would say, all I would say in that circumstance is raise it with the investigator and provide them with the explanation of how you've satisfied yourself that evidence isn't real and isn't authentic. And then, like I say, they'll take a view on it. And But with something like that, there's no harm in saying, well, okay, just these are the issues now. What do you think? And we'll pause it while you have a chance to sort of consider them and respond to them.
A very short question. How long you can have lien on the file, and what if the matter taking over by another forum and the nature of the application is sensitive and they require the certain information or documents from the firm there?
We don't really sort of. What we look at is what's reasonable in all the circumstances. So in terms of a lien, we would look at the specific circumstances of the matter and determine whether it was reasonable in those circumstances. So it's kind of difficult for me to give an answer to that because it's not. It just really does vary on the circumstances.
But can you simply refuse to the other firm not to disclosing or sharing the information or documents there?
Yeah, we certainly can do. We would only share the information and the evidence that we need to reasonably determine the complaint. What we don't ever do is we don't go behind a lawful lien. We're not going to say to the complainant, because we have these fishing expeditions and we do have firms holding lien over files, and people complain to us and they think that they can get the file back through our process. We're quite careful about things like that. If there's complaints raised and there's evidence that sort of determine whether the service was reasonable or not, we would share that as part of our decision-making process because that's fair on both parties to do that. But what we don't say is, oh, Mr. Jones, here you go, there's your file, and they say thank you very much. Now, we don't need to worry about the lien anymore because we've got those documents. But in terms of specifics, like the lady's passport, it's difficult to sort of to give you a definitive answer on that, but it would depend on the circumstances. But like I say, we don't go behind lawful liens. We don't ever do that. So.
Hi.
Hi.
Based on the previous experiences, I've just got a question for you. Considering a scenario where you receive a complaint from the Legal Ombudsman, and you looking at the file, you find out that the client has never actually complained to you at the first place.
Yeah.
Can you just write to the Ombudsman stating that we have got no record of the client complaining to us, so you could just kindly refer that matter back to us?
Yeah, exactly right, and that's what we do.
Instead, we could just start explaining our end.
Yeah. I mean, you can do it certainly if we contact you and say we've received a contact from this client and he's looking to complain. These are the complaints that he's bringing. You have a look in the file and say, hang on a minute, he's not brought that to us. That's basically these 6,500, 7,000 people I've referred to. We do get it a lot. We wouldn't, if you say, oh, hang on a minute, because we do ask at the first contact for the complaints correspondence. So we get the formal complaint and the complaint response. If there's been no formal complaint or complaint response, they're not going to be able to provide it. They might be able to provide a formal complaint that they knock upon their computer that day, but they're not going to be able to provide the response because there hasn't been a response. If we then think, well, hang on a minute, if he's not able to provide the complaint response, we'll just check with the firm. The firm say, yeah, cause we're not responding because we never received the complaint. Then we signpost them back to the firm to make the complaint at first tier before we can deal with it. Anyone else? Right, brilliant. Well, thank you ever so much for your time. I hope it's been useful and interesting for you today, and hopefully see you again soon. Thank you.